Hey everyone. Okay, hi folks. Welcome to SQE Land Law Mortgages. This one's a relatively short chapter compared to the other topics. Nevertheless, we're still going to go over everything and let us know if we have questions at the end. So yeah, let's get started. Okay. Number one, what is a mortgage? So a mortgage from a legal terminology is used to describe a relationship between a lender and a borrower. So the mortgage is an asset used by the lender, given to the lender by the borrower as a type of security in the event that a borrower doesn't end up paying. Um, Able to pay back the money they borrowed from the lender. And a mortgage specifically refers to the security that's created um, when the asset is a property, so related to land and whatever is contained in that land. Um, Mortgage, in the sense of the lender, actually means that the lender is providing or has a third party right over the land that is, right now, owned or controlled by the borrower. So, in the event that the borrower doesn't pay, the lender will enforce their right over the mortgage, take that as a type of security against the borrower, and take that property away from the borrower, permitting the number of definitions and requirements that follow this. 5.2 is mortgage capable of being legal. So mortgages are capable of being legal interests in land. Mortgages, generally speaking, are legal. The exception to this is if the mortgage wasn't created properly by deed, then equity will follow to secure that mortgage for the lender. So equity follows the law. Okay, formalities. So generally speaking, a deed is required to create a legal mortgage in relation to over the land, whether that land is the freehold, so owned fully by the borrower, or in certain circumstances, the borrower may have a lease, and a mortgage can still be created from a lease. Okay, um, as long as the landlord consents to that. That is another section. Okay, as a mortgage is capable of being legal, where the document lacks the requirements of a deed, equity may intervene. Exactly so. And of course, when equity intervenes, the same principles that follow an equitable interest also have to be applied. So in this case, Walsh versus Lundell, which we can review again. When a mortgage is created over an equitable interest, there's the other formalities. Okay, like it has to be written and signed. Important thing to remember in this case is that an equitable mortgage is only created when a legal interest or a legal mortgage fails to be created in the context of a mortgage. Okay, terminology, very, very clear. The mortgage is the asset, okay, that's used as security enforced by the lender against the borrower. The mortgager is the person that, the borrower, okay, the person giving that mortgage, okay, as the asset to the lender for security. And the mortgagee is the person that acquires the benefit of holding that mortgage against the borrower to enforce their security. Since they give their money. 5.5, lenders' powers and duties and protections of mortgages. So this is where it gets a little bit more complicated. This is talking about basically what rights and powers that a lender has to enforce the mortgage interest that they have as a third party right against the borrower, what makes sense, and when do you get to a point where, for instance, the house is sold, and the lender takes full ownership of that mortgage. Okay, so here it just says, right, there's different remedies for a lender to leverage against the mortgage, um, um, if they feel that the borrower hasn't paid money, maybe the appropriate mortgage payments over the course of 2 months. There's a specific period, or they're going to default. So the different remedies, basically enforcement powers that a lender has to enforce a mortgage. There are a variety of them. So there's like possession, the power of sale, and these are in orders of importance, meaning relative ease for a lender that they can enforce that remedy over the mortgage. So certain ones like foreclosure, or appointing a receiver are things that are usually the last resort. There's more formalities that you have to follow, and you needed to have exercised prior remedies before you are able to exercise these later ones, like foreclosure, for instance. So the remedies are kind of ordered in their accessibility for the mortgagee, for the lender. Okay, so let's see. Okay, so number one, possession. Possession is the simplest one for mortgagee, sorry, for the lender. And this is usually something that happens as the first step. A possession simply means that the borrower gets to take parts of the property of the mortgage, acquire the mortgage, redirect the rent, the belongings, the physical possessions inside of the property. That's all part of possession. And hold on, let me see. One important component with possession is, and with all these remedies, is the lender cannot do this by force in violation of the Criminal Law Act. They can take possession, but in a way that doesn't breach that. If they cannot take possession without breaching the Criminal Law Act, then only a court order. They have to apply to court in order for the court basically to force the borrower to give up his property for possession. All right. And usually possession is one of the first steps. It happens, when you forget to pay your rent or you're unable to. In the case of, the borrower for 2 months or something like that, then the lender can, at his discretion, exercise his right to take possession. Okay, so possession proceedings, there's different methods in which the possession can be enforced by the lender. So in this particular case, we're going to look at the pre-action protocol, which is specifically when the property is residential. So the way this works is possession proceedings, and with anything with enforcement of a mortgage by the lender against the borrower, the law usually favors the borrower as much as possible, kind of giving him he or she the benefit of the doubt to encourage the borrower to either be able to meet the financial obligation required by the lender. So, for instance, giving the payments, or if it's deferred, there's a set deadline. The borrower can prove to the lender that, I skipped 2 months, but if you give me 6 more months, I can still give you the payments. And so it's always weighed in favor of the borrower. So the pre-action protocol is one of these elements, basically requiring that if the lender does enforce possession, proceedings, they have to try to first resolve any disputes or arrears, outstanding dues with the borrower. They have to give them notice. They have to find a way, either like try to have them reschedule the debt, delay the debt, defer the debt, um, before actually enforcing possession. So there's some amicable, all right, conversations that should happen, that are required to happen in this pre-action protocol between the borrower and the lender before proceedings can begin. So um, in this particular case, additionally, the courts also can get involved in possession proceedings. So notice in the prior slide, um, the lender can enforce possession proceedings if they don't violate the criminal code. So that means they can enforce that without the courts ever getting involved. Um, in certain circumstances, when that happens, Section 36 of the Administration of Justice Act is basically there to allow the borrower to request to the court to somehow stop the lender from enforcing the possession proceedings if the borrower feels like it's coming on too quickly, or the borrower can prove to the court that they can still meet the outstanding dues um, for the lender, um, and basically trying to stop. And then the courts, if they can see that, will stop the lender from exercising possession proceedings. Um, to say that in more simple terms, statutory law is also there in addition to the pre-action protocol, which basically states that the court, in its sole discretion, can defend the borrower and stop possession proceedings that are enforced by the lender if they feel that that is like an overly harsh or unconscionable action made by the lender. If the lender is proceeding to enforce possession proceedings too quickly or too urgently, the courts can stop that if they find that to be unfair um, in the eyes of the borrower. All right, so basically, court statutory law is there to help, again, protect the borrower from unnecessary possession by the lender when the borrower can clearly, for instance, pay outstanding dues, even if they've stopped paying for like 2 months, due to certain requirements, which we'll see in the next slides. Okay, so this is strict duty to account. This is just something that's there. It's a duty. Okay, it's an obligatory duty, a standard of care that the lender must exercise when they have acquired the mortgage. This is just it's just a duty, and this duty is a very practical concept. Simply where if the borrower um, if the lender does acquire the property and let's say it's making income, if the property or the mortgage is valued higher than what the debt that was owed to the lender, then the lender has to give that extra money back to the borrower. They can't take a surplus of what it is, because in certain cases, your mortgage can actually be more than the debt owed. You, for instance, ask the bank, who's the lender in this case, to give you $200,000, and you would mortgage your house, which is maybe $500,000. If the bank does acquire the mortgage, enforces the mortgage, which is your house worth $500,000, they can't take all that 500,000. They have to take the 200,000 and then give you back the $300,000. If they sell the house on the market, or something like that. So that's the strict duty to account. Account means like accounting. They can only take the dollars that was owed. That they've given to you, and they can take that back. but nothing more than that. Okay. We'll look at appointing a receiver after this, which is a similar concept. Okay, so next is the power of sale. So, let's say the borrower does obtain possession of the property. Um, Possession is a first step before exercising the power of sale. If the lender chooses to exercise the power of sale, that basically means they will sell that mortgage, as a financial asset on the market to basically obtain the cash value, the liquidity coming out of the coming out of the from that mortgage. Um, so by separating power of sale and possession does come first. There is a value of just possessing the asset without selling it. So, if that house or something is producing rent or income, that can be used for the lender to immediately pay, fulfill the debt that's owed to them. Or when you take possession, you're giving a strong signal to the borrower that like you have to stop whatever it is that you're doing until you give me the money that you owe me, right? So that's possession is about control of the property, and power of sale is to exchange that property after you've obtained control, which is possession. So after to get the cash return on that property. So like possession, the power of sale, there are certain principles and conditions that have to have come up before the power of sale can be exercised by the lender. So the power of sale in this case must have existed, it has to have arisen and become exercisable. So we're going to see what that means. So to exist basically means that, well, usually the power of sale exists if it's stated inside of the deed or it's implied, unless the power to sell the mortgage was explicitly excluded. So there is a discretion to exclude that. A borrower, when receiving $200,000 as part of that agreement with the lender, can actually be like, okay, you can take possession of my mortgage of my house, but you can't end up selling it. Okay, like that's not one of the authorities or powers that you have. So that's why the power of sale has to first exist first, because sometimes it can be excluded. So the power must have arisen. That means that certain conditions must have been fulfilled, or I should say, certain conditions have to have not been fulfilled by the borrower for that power to give that power and discretion to the lender to exercise. So, a couple things here. Generally speaking, so the legal redemption date, which is the date in which the debt is due to the lender, has to have passed, usually 1 month into the term. So if they haven't paid for a whole month, then the power to sell the mortgage can arise. Usually, this is expressed inside the deed. This depends on different mortgages. It depends on the specific details, like maybe how much the mortgage was worth, and how much money was loaned in the first place. Okay, so the power must have arisen in that sense. Can't just come randomly. And probably for this as well, generally speaking, the lender must have exercised possession first. All right. Okay. So the power of sale must be exercisable. This is just a little bit more expanded from must have arisen, the power. So basically, there has to be a concept where the lender has given the borrower notice to repay the loan amount, and the borrower has not repaid. So again, this is some amicable discussion between the borrower, friendly discussion between the borrower and the lender, to the extent that that's considered friendly in a legal way. Okay, so the lender must have given them notice. Okay, like at least alerted the borrower that you haven't paid me. You were supposed to pay me, but you haven't paid me for at least 3 months after the initial notice was given. Okay, uh, or if there was no notice that was provided, naturally the borrower must be 2 months in arrears, which is debt owed. Okay, so 2 months into debt being owed, they haven't paid anything they were supposed to, then the power of sale can be exercisable, or the borrower has breached a term in the mortgage, other than the requirement to pay the debt. So some other one, like I don't know, maybe they lied about their mortgage, or the mortgage wasn't the original value they claimed it to be, or some other thing in the agreement where it's a material breach, presumably. Then the seller can exercise the power to sell uh, the property. It's important to note that these three requirements are statutory law, so it follows in the LPA, um, which means that these are firm requirements. Okay, so these are memorized, commit to memory. Okay, it's specifically either 2 months after the arrears have been due, or notice after, or notice has been given, and 3 months after the notice, the lender still hasn't, borrower still hasn't paid the amount after notice was given, or there was a material breach in the mortgage. Okay, so this is how the power of sale must be exercisable. In addition to these requirements, these are the implied requirements, okay, that can be relied on only if there was no expressed requirement, other requirements in the mortgage deed. Okay, if the mortgage deed says otherwise, like maybe it's 5 months in arrears, then that will follow. Okay, uh, for the power of sale to be exercisable. Okay, um, all right. So lenders' duties on sale. So lenders' duties on sale um, is basically the obligation on the lender, where um, the lender must sell the property, okay, so the mortgage, in good faith. It's related to this concept. Okay, so basically, like, when you sell the mortgage, it has to be at a fair marketed price. The lender must have gone out of his way to like advertise the property, bargain for it at a fair competitive offering on the market. So it's important that the seller cannot undersell the mortgage. If they really need the money and they undersell the value of the property, this is actually a breach in their duty, and a court judgment can actually reverse that transaction and say, like, you undersold this mortgage, like this house, so like you got to do it again, basically. So this is the duty on the seller, where there's an expectation or an obligation that they have to sell in good faith, at the market value. um, they have to do it in an auction or something. Not cheap borrowers. Okay, take reasonable care. Exactly. uh, Lenders are not under an obligation to delay, so you don't have to unnecessarily delay it, but you have to be fair, basically, is what this means. Okay. And then following that, also, like, obviously, as part of that duty, which was related to the strict duty to account, if the lender does end up selling it at a fair market value, the property, and that value was higher than what the lender was owed, then the lender has to return that extra money back to the borrower. Okay. Um, so this is the duty of care, okay, of the lender. All right. Effective sale. So this is an interesting concept. This ties into covenants, covenants, and easements from before. These are interests in land. Uh, can be overriding, may not be overriding. Talk about that in another chapter. But the effective sale is actually the priority in the lender in exercising its right. So sometimes a mortgage